Yes.
My lord, I like this matter is actually filed in 2019. This
Listing.
pending, yes, for listing.
Tomorrow.
No, no, on 10 or 9. May please, my lord. I may be allowed to move an application for withdrawal of a writ petition, my lord. Today, my lord. Oh, sorry.
My lord, I would like to mention, my lord, writ petition for listing tomorrow, my lord, is an urgent matter from department side, my lord. This is regarding, my lord, shifting of quarter, my lord. So we want to construct this project is getting delayed, my lord. That's right. Obliged.
May I please, your lordship? Lordship, I beg to mention you. There is one unlisted matter, lordship. That matter may be taken up today, lordship, at 2.
What is the urgency?
Lordship, the tender, the technical bit of the tender, this matter is pertains to tender matter, lordship. Now, on the last occasion, lordship, we have already filed an application before this honorable court, and after the this honorable court was given a direction to the department to open my bid, lordship. But instead of opening the bid, lordship, they have just on a flimsy ground, they did not open my bid again, lordship. Deeply obliged.
May I please your lordship, I beg to mention item number 12.
Item number?
Item number 12, your lordship.
Yes.
Lordship, matter may be adjourned for today.
Lordship, I'm appearing for respondent number 3 in the
There is no stay.
No, stay, Lordship. Lordship, we can be listed on the 24th November.
24th.
Yeah. Deep obliged.
Item 12. Item 12.
My lord, I beg to mention item number 19.
1.
Item number 19. This matter may be kindly fixed.
Already stayed. Division bench has already stayed. Contempt case, isn't it?
Yes, ma'am.
So the judgment which you allege that there is a violation that has already been stayed by the DB.
That I have been instructed by the counsel for the petitioner. I have no idea about this matter. Moreover, the conducting counsel is from Delhi-based advocate.
Okay, we'll adjourn it, pass an order when the matter reaches with.
Yes, ma'am.
My lordship,
Yes.
I beg to mention item number 17. This matter may be paid in completed. Matter may be fixed on 16 of this month.
Have you taken dusty service?
Yes, lordship.
Where is this affidavit?
Sorry, lordship.
Wait for your turn.
My lordship,
Yes.
I beg to mention item number 8, your lordship, on behalf of B. Picha, Standing Council of RD.
Item 8.
8, yes, Lord.
My lord, I am appearing, my presence may be recorded. I am appearing for respondent number 5.
Okay. You are Mr.
T. Tarin.
T. Tariq, Learned Counsel for the petitioner, praise for adjournment. Mr.
My lord, can it be when I fixed it, my lord? 18th of December.
When give us a day. However, submits that matter a date may be fixed. Prayer is allowed. List this matter on
My lord, 18th of December.
18th of
December, yeah.
18th of December.
Deeply obliged.
Yes.
Obliged. My lord, I would like to mention item number 20 on supplementary hearing, my lord. 2029, my lord. The
29.
petition doesn't want to press the matter, my lord. That's why I wanted to withdraw it.
Okay. The Learned Counsel for the petitioner submits that petitioner, he has instruction not to press this present petition. Accordingly, same stance dismissed on not being pressed.
Yeah, my lord. My lord, I beg to mention item number 16, my lord.
16.
16, my lord. Matter may be fixed after, my lord, 4 weeks. My
Who is for respondent number 4?
My lord, is the
I am for the respondent number 4, my lord.
When will you file?
Actually, my lord, Learned Counsel for the respondent is out of station.
We are giving you how much time? 2 weeks time to file the counter.
Till and my lord, interim order passed earlier, we continue till further order, my lord.
Okay. The learned counsel for the respondent number 4
Four.
prays for further 2 weeks time to
2 weeks.
file counter affidavit. Affidavit in opposition. Full stop. Prayer is allowed. List accordingly. The interim order passed earlier shall continue until further orders.
Obliged, my lord.
Your Lordship, I beg to mention item number 28 on behalf of petitioner advocate Tony Pertin, who is currently out of station, Your Lordship, for personal reasons. However, he is scheduled to return by tomorrow, Your Lordship. So that's my
When do you want?
day after tomorrow, Your Lordship, on
Day after
8th.
tomorrow. List this matter day after tomorrow.
Much
On
obliged.
the prayer of the learned counsel for the petitioner, list this matter day after tomorrow.
Yeah.
Yes.
And I beg to mention item number 10. In this,
Item number
in this-
10.
Yes, Lord. In this matter, we would like to file some certain additional documents, so we may be given 2
You are
weeks
for a
time
petitioner?
for the petitioner.
Okay. You are?
T.Y. Bhutia.
T.Y. Bhutia, learned counsel for the petitioner, submits that she may be allowed to file some additional document by way of an affidavit, which are very necessary for a determination of present petition. Full stop. Prayer is not objected. Accordingly, same is allowed.
2 weeks.
List after 2 weeks.
2 weeks, obliged. Also, Your Honor, I beg to mention WPC number 310 of 2023 to be taken up tomorrow. This matters with regard to eviction. It may be taken up tomorrow. Obliged.
May I please, Your
Yes.
Lordship. Lordship, I beg to mention item number 25 and 26, Lordship,
25,
and 26, Lordship. I'm for the petitioner, Lordship, in the instant matter, Lordship.
25 and 26.
Lordship.
Why should you not? You are for a petitioner.
Lordship, this matter, Lordship, we have to, in the last occasion, we have this honorable court has directed me to take a step on the private respondent, Lordship, which inadvertently has not been taken, Lordship.
It is submitted by the learned counsel for the petitioner that steps upon respondent number 1 to 4 has not been taken inadvertently. Accordingly, he submits that the steps should be taken during the course of the day.
Lordship.
Full stop. In view of such submission, matter stands adjourned. Steps be taken upon respondent number 1 to 4 in terms of office note dated 3/11/2022
Deeply obliged.
during the course of the day. List after 4 weeks.
Deeply obliged, Lordship.
Lordship, I beg to mention item number 11, Lordship. Lordship, I need some time here, Lordship. This may be fixed after 2 weeks, Lordship.
Okay, on the prayer of learned counsel for the petitioner.
Not petitioner, Lordship. For the- I
Respondent,
have
who is
taken-
for the petitioner?
Yes, Lordship. I am for
Yes,
petitioner, Lordship.
any objection?
No, Lordship, last chance, Lordship. 2 weeks.
Okay.
Yes, last.
Learned counsel for the respondents prays for further 2 weeks time
Yes,
to
Lordship.
file affidavit in
No,
opposition.
affidavit has already been
Huh?
filed, Lordship. Affidavit has already been filed.
Now, why you want time?
Lordship,
He says that his land has been taken.
Here, Lordship, some affidavit is required, Lordship, from the land department, Lordship.
Who is land department? Hamduk. Who is for the land department?
council is there, Lordship. They have starting council.
Okay, no affidavit has been filed by the, what is the, you call this land department?
Standing council, Lordship.
No, no, what is
Land
that?
management.
Huh?
Land management.
Land?
Secretary land management, Lordship.
Land management.
Yes, Lordship.
Land management department. Affidavit on behalf of land management department shall be necessary. Accordingly, 2 weeks time is granted to file such affidavit. So in your land, police station has been constructed.
Lordship, here is the case, Lordship.
There is no interim order.
No, Lordship.
Yes, no interim. You have taken the land without following procedural law. Yes, next.
My lord, may I mention item number 27, my lord?
27.
Yes, my lord. Here, my lord, I am appearing on behalf of my lord, the private respondents. My lord, I need to take instructions, the private respondents of whom particularly I have to appear, my lord. And all family members has been appeared. Some of them has already expired, my lord. So therefore, my lord, some more time may be granted, my lord, since other parties also.
Both case dismissed. What writ court will decide?
As per last order, probably I think.
No, he says that he appears for all the respondents of the deceased representative of respondent number 3.
Private respondent.
Private respondent number 3, 3A, 3B, 3C, something like that. Now he has not filed wakalatnama, but even then affidavit was, this was admitted. So
For some of them,
we
madam.
hear it
3 weeks time, I'll take it.
on the prayer of the learned counsel for the respondents. Matter stands adjourned for the 3 weeks.
My lord.
Both
Declare-
the courts decided against the bank. What read court will decide? Can we reopen these facts? This question of limitation is a fact, both facts and law. Facts part we cannot go in a read jurisdiction. Yes.
Deeply blessed.
May I please, madam? My lord, here the petitioner, my lord, is agreed by the manner in which the investigation has been carried out and the charge sheet has been filed. And from the charge sheet, my lord, even if the trial goes, my lord, it's sure, my lord, that the conviction of
But most of the witnesses, they have said, yes, it happened. But
That's right.
it happened, but we do not know who are
do not
these
know
people.
who. And here, my lord, will see.
Can that be changed in a reinvestigation?
My lord, not
But
only
your
on,
stand is fine, you have identified. You have identified.
not even examined, my lord. It has been
Okay,
shown that I have been examined.
issuing a notice for the time being.
My lord, my lord, here what's the problem is that on 9th of this one, for my examination, case has been fixed. If that proceed further, my lord, so that may be, my lord, state, because my lord knows, without fair investigation, no possible at all, my lord, to get the this conviction of the accused person, my lord. So, my lord, fair trial completely depends on the fair investigation, my lord.
Hard, Mr. Learned counsel for the petitioner. The present petition is filed for direction of re-investigation of Raga police station case number 30/2020 corresponding to GR case number 19/2021. The petitioner was the informant in the aforesaid case. According to the petitioner, the investigation has been carried out perfunctorily and therefore a re-investigation is required for ends of justice. First of all, this matter needs further consideration. Issue notice returnable after 4 weeks. In the meantime, the further proceeding of GR case number 19/2021 pending before trial is pending before
Chief Judicial Magistrate 0.
Chief Judicial Magistrate 0 shall remain suspended.
Deeply obliged.
My lord. In item number 2, my lord, I'm appearing for Escano 3.
Where is the suit? It's a dispute between you are the landowner
Yes.
and he is the builder
Builder. My lord. And. My lord.
and you are the
Suda.
department.
Yes, yes, my lord.
Department.
My lord.
Now, what was your suit for? You file a suit.
No.
Who filed a suit for declaration?
No, I file a
You
suit
file a suit
against some third party,
Not against.
not against him,
not against them,
not against him also.
yes, against some third party who have encroached my land.
Okay, in the meantime, somebody else.
They have abandoned and someone have encroached.
Just a minute. So according to you, they have abandoned
Abandoned,
and some third party has encroached, you file a suit.
yes,
And initial agreement was between you and him.
yes.
It's a more or less, well, it's a tripartite kind of arrangement.
But can there be a contract more or less?
No.
It is more or less.
It's my lord.
What was the contract? Contract was between you and him.
Initial agreement was definitely between the builder and the landowner. My lord.
Builder and the landowner.
My lord.
Where is the role of this person, this state?
there was-
Anything in the contract?
My lord, there was
That is the issue here.
pertaining to the same parcel of land. My lord, there was a MOU signed between the builder and the landowner. My lord.
So in that case, you need you are seeking for an arbitration.
My lord, because
No, not because, that is the
My
fact,
lord,
because will come later on.
if my lord will just allow me to, apprise this honorable court with certain facts, which is really necessary, to come out with.
What is your case in writ petition?
My case is that respondent number 1 and 2. 2 has respondent number 3 authorized the respondent number 1 to take over my land, the builded area, stating that they have.
There is a stay.
There is no stay, but they are also not.
But you have an injunction in your own, in your suit.
Title suit has been declared in my favor.
Already decree passed.
Yes.
So that you are owner, there is no dispute on that.
Even before also I am owner. I have a.
No, that
yes.
we understand.
Yes.
Now, what is your prayer in this writ petition?
My prayer is the Secretary Housing have passed one order that from today this land where they have built constructed some portion of land belongs to them. Title and possession of that portion is taken over by the Department of Housing. The Secretary Housing, he himself passed that order.
No, is there any agreement between you and the housing department?
No. My
Your
agreement.
agreement is with him,
Which-
where now he comes for an arbitration.
Yes.
Yeah, isn't it?
Yes.
Now, how can you pass that order? Is it not a tripartite agreement?
No, of course, agreements between these two people.
So who are you to say that this land?
Because
You might have many agreements with many
They
persons.
made a joint venture. This land was given to the department for he was the builder, construction company. So
What action have you taken against him?
That's why, Malab. In the midst, they left the project.
Huh.
The persons who deposited the amount with the department, they filed several writ petitions before this honorable court. And the department didn't have the option to pay back all those in crores of money. Has to be
So
paid.
any security taken from him, them?
Land was, that particular plot of land was given to the department for construction of that house.
Who gave that land to you?
Of course, because it's
Who gave the land to you? Tell us. Tell us that first.
Both of them, I would say.
Where is that document? Giving land to them.
MOU is there, Malad.
Certain fundamental things.
Basic problems that, actually in this case, we are actually escaping a lot of things in the background, and then after I think we will not be heading towards the right way. This is why, I was just requesting this.
No, we understand. There are certain, we understand, we'll hear you. But there are certain fundamentals in the case.
No.
Isn't it?
Yes, my lord.
The fundamental is that there was a contract between you and him.
Yes.
That there will have a building, he will get that much of percent, so on and so forth. You show me that he has authorized you to enter into an agreement with government. Show me that.
Well, basically, let me come out. Let me read out certain fact. The agreement signed. That is the fundamental thing.
Yes.
I would agree that the agreement signed between me and the.
If he has agreed that we will have an agreement, there will be a construction. You are at liberty to enter into a contract with the government and do this and that with the MU. I have no objection.
My lord, first of all, my lord, may I take you, my lord, to the agreement itself? That is the part of the writ petition, my lord.
Not whole agreement. Show us that part.
Yes, my lord.
Show us that part.
Yes,
he has authorized you.
Because, my lord, this is a joint venture agreement. This is
We
not
understand.
a simple agreement. It's a joint
No,
venture.
how the government is brought in that
Yes,
agreement,
yes,
I
my
want to
lord.
see that.
Yes, my lord. I'm coming to that, my lord.
Show us that first.
Yes, my lord.
We'll go to other things later on.
So, my lord, please come to, my lord, this agreement, my lord, so that.
Yes, tell us. We are coming.
Yes, my lord. That is the document, my lord, obviously.
Yes.
Yes, sir. So, it's a 27 page, running page 27 of their writ petition. That is the annexure 2, my lord. That is the agreement signed 17th February 2010. between builder and the land. Yes, my lord. Now, my lord, at the very face of it, it's showing that, sir, have you got that, my lord? That annexure 2?
No, just show us. This is what is the salient feature of this contract. We want to know that.
My lord.
You are authorized to build a building in terms of this contract.
My lord, everything is written in black and white. My lord. This is what I'm just showing the paragraph, my lord.
Yes, show us the paragraph.
Yes,
show
my
us.
lord. So, my lord, if my lord has got that, land, my lord, in the next page of 28, the top paragraph. Whereas the builder has approached the owners and have shown their interest in constructing affordable housing in JV and PPP mode with the Department of Housing, Government of Arunachal Pradesh, my lord. So this clearly shows that there is a consent between the landowner and the builder that the government, that there will be one other party involved, that is the government. If this is not consent, my lord, then what is the consent?
Kindly come to the fourth paragraph.
My lord. My lord, the fourth paragraph, whereas the owners and the builders have mutually decided, approach the Department of Housing, my lord. So
Approach the Department of
collectively,
Housing for what?
to allow this scheme, JV/PPP mode as per the government scheme with the builder, my lord. So collectively, they have already signed an agreement that they will approach the government for this this particular project, my lord. Now this cannot be the convenience of the landowner that one can approbate and reprobate at the same time, my lord. Besides, my lord,
where is the agreement between you and the department?
Department, they have my department is, I think that is part of the arbitration proceeding, petition that we have filed, my lord. I'm not sure whether, because they have annexed the documents as per their convenience, my lord, just to mislead reasonable court.
No, that's wrong, submission. I have nothing to do with the agreement between you and the government.
No, my lord.
So I need not to
I will
annex it. This is wrong.
I will come to
submission.
those points, my lord. What are the, the entire petition is just bunch of lies and nothing else. So let me come out. So far as my arbitration proceeding is concerned, my lord. That is as page 121, my lord, of my petition. That is item number 3, my lord. I petition, sorry, my lord. Sixty-seven. So it's a 67, my lord, page 67.
Where is page?
Page 67 of the arbitration petition, my lord, that has been filed by the builder, by us. This is the MOU, my lord, of 3rd September 2010, my lord. It has been signed between SUDA, that is Secretary of Urban Development Department, which is through a State Urban Development Agency, SUDA, and the builder, my lord. The petitioner in item number 3, my lord. So the very basis of this MOU, my lord, is the JV agreement signed between the builder and the landowner, which can be clearly manifest, my lord, in second page 68, my lord, in the second paragraph. If my lord allow me to read that paragraph.
Have you been paid money?
Yes, my lord.
For
Escrow accounts?
around 190 lakhs. I'm told that over 90 lakhs they have paid. Now what they are claiming
And
that
what the government is taking action against these men?
nothing,
Huh?
nothing has been taken.
Definitely,
You are taking action against these men, and what about them?
we consider both of them together. not
How
separate.
can, why have you not had an agreement with these three together? You are making promises and all things to a third party to the agreement. He is not a part to the contract. You are having contract with him on the basis of some promise between them.
Yes.
And you are now taking over the land from him.
Malad, but unless they showed us the land where they will be building, Malad, the project wouldn't have.
Who is in possession of the land now?
It's my position.
It's your possession.
Several buildings have already been constructed now.
Who constructed the building?
Builder, Malad.
Huh?
Builder.
My lord, let me apprise, my lord, with the
Is he a
circumstances.
party in this petition?
Yes.
Yes, my lord.
Have you filed affidavit?
Yes, my lord.
You
I'm
have
coming to
filed-
that, my lord.
Huh?
I'm coming to that, my lord. My lord, let me just allow
No,
me to just complete my before coming into any conclusion, my lord.
No, we are not coming into the conclusion. We are
let
just
me-
having
yes,
a
my lord.
bird's eye view of the thing.
Yes, my lord. So, if,
No, before my friend submit-
because he's the petition, my lord, in item number 2, my lord, so let him finish, then after I'll just finish my arguments. my
Petition
lord.
को हमको थोड़ा पहले बताने दो.
Yes.
In my writ petition, the basic core issue is that whether company and department take over my land without my consent.
Then you answer the question whether in terms of the agreement
Yes.
between both of them, you have received the money.
No, that money there are several issues which has to be decided, but that issue has to be decided through arbitration. That I am not opposing that.
We will appoint an arbitrator between both of you.
Yes, my lord. This is
And
what we are for.
in writ petition, my challenge only against the order dated
Propose a name.
In case of arbitration, the limitation is over.
My lord. That part will take care.
File a petition now after, this limitation is 3 years.
Yes, my lord.
No, limitation 3 years, but when was the demand?
Yes,
When was the
yes.
dispute started?
17,
Those things.
2017, my lord.
Huh?
The both of them,
That
in
part-
order
that
to
part,
cover
let-
their
let-
case,
let them oppose
they're-
them while-
they're making me scapegoat in order to cover their own face.
Yeah.
Are you going for final disposal today?
My lord,
Tell us, or otherwise we'll not waste time.
otherwise also I have there is two agreement between me and
Answer me the first question. Are we going for final disposal today? Or we'll fix it for hearing?
this may be fixed for hearing.
My lord,
Tell us that, otherwise we will not waste our time.
I think, my lord,
Because they have raised an objection as regard the limitation. We'll have to answer it.
yes, my lord, I am going to
No, no.
answer it, my lord.
We'll hear
I'm
you.
going to
Don't
answer,
be so
madam.
excited. We'll
Yes,
hear you. But problem is that, are you ready for the final disposal? Tell us that.
I am not ready to do.
Tell us that.
Yeah.
Otherwise in halfway we will not do that.
Yes.
So,
So
Next
when?
day-
Tell us when.
Next day may be fixed.
Huh? Give a date. And pleadings are complete?
yes.
Where is your objection between the arbitration between these two parties?
He has filed an application seeking the direction from this court for an arbitration
Between-
between him and me.
Not
No,
be-
no, no.
No,
This
no,
is
no,
also
no.
part of it.
Arbitration is between these.
All three of us, three of them, my lord. I have the judgment, my lord, which will, I'm going to show it, my lord, in two ways, my lord, whether I can file this argument, arbitration between, I mean,
Two
I can-
separate contracts. You are
two separate contracts, but all the contracts are joint. I mean, that
okay.
is
You want to say
together.
so
Yes,
joint
madam.
arbitration,
Yes,
then
yes, yes.
there is no
So-
multiplicity of
Yes,
litigation.
there is a
20
judgment.
20
Yes,
November.
behind.
Huh? When?
20 November.
20?
November.
my lord,
28th of November. He comes.
actually, I from Delhi, my lord. So, my lord,
You will
this is
have
why
to-
I just want to just,
It's in your interest.
my lord.
Coming from Delhi is in your interest.
As my lord, the issue is, my lord, because I just wanted to, on the 2 points, my lord, they have raised it. I mean, that basically in arbitration.
See,
my lord.
he is seeking an adjournment
So
on
far as this
28th.
petition is concerned, my lord.
Is it not
No, no, no,
important
that is
for
part of it, but
arbitration?
obviously, two valid objections, my lord, that has been raised by my learned friends, my lord. So anyways, my
Yes,
lord,
ma'am.
whatever, my lord.
2020.
And my lord, can I?
According to his convenience.
I will give preference to
Yes.
his death.
My lord, if my lord, it will be convenient, my lord, then is there in the month of January or in the January, my lord.
Give me your date.
Just. Anything between 15th and 20th January, my lord. Any date, whatever convenient to.
Let it be 20. 15, I have again go back.
28th of January.
Judges.
Just take it down. Joint duty order pass koribo. The writ petition is filed assailing an order dated 3/9/2008 issued by the Secretary Housing Government of Arunachal Pradesh whereby the disputed land in question was directed to be transferred, possession and ownership of the disputed land in question was directed to be transferred in the name of Housing Department, Government of Arunachal Pradesh. It is the case of the petitioner that the petitioner is the owner of the aforesaid land. Full stop. The arbitration petition relates to an agreement dated
Agreement is 17th February 2010, my lord.
17 February 2000
And my lord, to there too.
and 17 February 2000
And 2nd November 2009.
and
2nd November 2010.
17th 2010. Please give the date. Here it should be prompt.
Yes, my lord. There are two agreements. 3rd September 2010.
Give me the first agreement between
First agreement is 3rd September 2000. 17 February 2010. This is the first
17 February 2010
is the first
entered between the present writ petitioner and the petitioner in arbitration petition. Full stop. Full stop. And the second agreement relating to the prayer of appointment of arbitrator is dated
3/9/2010.
3/9/2010 entered into between the arbitration petitioner and the
SUDA.
and the
Housing Department.
Housing Department within bracket SUDA. SUDA for construction of
Mass portable.
affordable housing over the plot of land belonging to the petitioner, which is sought to be transferred in the name of the housing department by which is under challenge in the writ petition. Full stop. The learned, though pleadings are complete, the learned counsel for the writ petitioner prays that he may be granted some time for preparation of the matter. Full stop. As the learned counsel for the arbitration petitioner is an outstation lawyer, he prays that a fixed date may be granted. Accordingly, the matter is fixed on 28th of January 2024, an endeavor should be made to dispose of the entire matter on that day.
My lord, oblige me.
You think over a solution which will benefit the other persons also.
Yes.
All monies are taken away. No? Milk cooperative.
Yes, Reverend Advocate General is appearing in this matter for the government. Milord, let me outline the matter very briefly of all the read petitions, Milord.
The matter is that you are a doctor, veterinary doctor,
Correct.
employed somewhere. Now you have become a managing director of a cooperative union.
Correct.
Now therefore, they have taken action against you, whether that can be done or not.
That
is
can
the
be
issue.
done or not.
That can be done, whether you can be a managing director of a milk cooperative society. That is the issue while having substantively serving the government. This is the issue.
Yes, ma'am. Whether we can bring him back, that is also an issue. What is under challenge is, we said that you have continued as managing director for long enough,
Yes.
for several 15 years now. Please
No,
come back.
You mean to say that he is exclusively MD, not serving the department.
Substantive position is in veterinary department.
He is not
It's like
serving.
our apex bank money. In many.
Understand.
Now, the challenge in the first read petition is, we said you come back. And there are serious allegations against you. We suspended him.
Now where is he now?
He is continuing by virtue of an interim order.
Bad.
No, Lord. Learned AG has made two false submissions.
Yes.
The first is.
Now first tell us, just I have gone through, it's a bird eye view. We know that your substantive post is in veterinary department. You are a veterinary doctor.
No dispute, Lord.
No dispute on that. Now the board of that milk cooperative union has elected you as the
Not elected.
whatever annual general meeting or whatever, you are the managing director.
Correct, Lord.
Now we continue that managing director.
Correct, Lord. Just one correction, factual correction. He has neither been, as per the bylaws, there has to be a recommendation by an expert panel. When this milk union was formed, the government deputed him. And that is how he has been continuing. That procedure.
So government want him back to his service. He will have to come. That is the simple.
Well, that is no more a res integra in legal parlance. And I will have to respectfully differ with the contention raised by the learned Advocate General for the reasons that a government employee can partake in any registered non-governmental organization with or without the permission of the state government. And subsequently, even the prior permission also. At the same time, the Cooperative Milk Union is a body registered under Section 9 of the Society Registration Act. It governs by its own bylaw. Therefore, except or otherwise, to a elected post, a government employee cannot hold that post. Here is a case, I am appointed. I am not an elected person.
You are appointed as MD by whom?
By the board of directors of the Milk Union, Milord. To that aspect, Milord, in my affidavit, I have made it very loud and clear as well, Milord, that I have taken permission from the Secretary of Animal Husbandry Department as well as the director, Milord. Now, therefore, CCS rule will not come into play. Being a private organization, with the consent, I have gone to the Milk Union as the MT being appointed by the board of directors for the ratified. So therefore, the question of law that has arisen before us is whether a government employee can hold the post of managing director in a private organization.
Okay, we agree. Suppose that you can hold a post of managing director.
Correct.
Government wants you to be come back and be posted somewhere else as a
They are
as
doing
a doctor looking after the cattles of in a place called Tawang.
I bow down the opinion that has fallen from
So
Lordship.
go there, go to
No.
Tawang and have this, what you
No, no.
call it, yak.
No,
You treat the yaks
no, that is that
and
yak.
be managing director.
Yes, that yak and milking part is already being done under full immunity and protection of the state government itself. They have been posting me. Now, my lord, the only question is, can the suspension order and the departmental inquiry that has been instituted against me, the action of which is not falls under the CCS rule, can they suspend and can they order departmental inquiry against me or not? Respectfully not. My lord,
So you want to say that your employer cannot either put
touch
you-
me. They cannot touch me. You have every liberty to transfer me, but I can still continue as a managing director.
Okay, give us the facts.
And my lord, for a moment, my lord,
Yes.
before I give lease of debt to my lord, kindly take CCS rules. My lord.
No, we'll first go to the facts.
My lord,
Then we'll
that will clarify. Then I'll give you the list of debt. My lord. CCS rule 15, my lord. Where is that? It is here. After Nilay sir,
CCS
appearing, after Nilay sir, Reverend Nilay sir, appearing against Learned Advocate General is a privilege for all the advocates here, my lord. Kindly come, my lord.
CCS.
Yes, CCS Conduct Rules 1964,
Rule
15, my lord. Page 429, my lord, if we are having the same copy. Page 429.
Rule 15.
Yes. 429. Page number 429.
No, there is something. It is 247. CCS, CCA rules, is that it?
Yes, CCS Conduct Rules, my lord, 1964. Page 429. We are having the same book, my lord.
Page 429.
Yes.
Conduct rules. Okay.
Yes.
429.
Rule 15.
Private trade or employment.
My lord, kindly come.
Private trade and
Private
employment.
trade or employment. Subject to the provisions of Sub-Rule 2, no government servant shall, except with the previous sanction of the government, engage directly or indirectly in any trade or business, or negotiate for or undertake any other employment, or hold an elective office, or converse for a candidate or candidates for an elective office in anybody, whether incorporated or not, or D, converse in support to any business of insurance agency, commissions agency, etc., owned or managed by any member of his family, or I falls under this category.
Which category?
D. E. Miller. Take part except in discharge of his official duties in the registration, promotion, or management of any bank or other blood. Company registered or required to be registered under the Companies Act 1956 or any other law for time being in force, or any of cooperative society for commercial purpose. Now, my lord, it is very loud and clear, my lord.
Okay.
My lord, for brevity,
Hmm.
we may directly proceed to read petition 391.
Three?
It covers
391.
91, my lord.
Why so many repetitions?
My lord, subsequently,
This summarizes the everything.
this summarizes everything. There was another read petition 223 where this was clarified that I can hold it because they have withdrawn it also. My lord, before we proceed to appreciate the actual factual metrics of this case, my lord, I furnished this order dated 8/4/2019 in read petition 126. Then, my lord, we will.
Space.
Yeah, I am giving. We will conceptually very clear. The question that has been posed by my lord is there that Lordship's brother Nani has raised this particular question. My lord, shall we read together, my lord? This is German of the whole case. My lord, this having noted, if my lord permit me to read.
Yes, yes.
Having noted the submission of Mr. Saikia, learned counsel for the petitioner, that the society in question is purely a private organization not connected with the government of Arunachal Pradesh, or for that matter, any other government, I deem it appropriate to direct Mr. Tapin, so and so, to take instruction as to how a government employee, namely DVO, in the present case can be spared by the government of Arunachal Pradesh to render services to an organization which is purely private in nature and has got nothing to do with the affairs of the government of Arunachal Pradesh. Next paragraph I'll read. This court, being of the prima facie view that no service of a government employees can be spared to render his service to a purely private organization unless the rules provides to the contrary, this court deemed it appropriate to stay till returnable date the order dated 5/03/2019 issued by the Secretary, Department of Animal Husbandry and Veterinary Government of Arunachal Pradesh under memo number so and so, to the extent that the petitioner has been asked to hand over all the charges and responsibilities relating to the post of MD, APC, MPUL to private respondent.
If it cannot be allowed, how can you be allowed then?
Exactly. The matter ends there. Yes. So, no, I have to be fair, my lord. I have to fair in my
Because
argument.
if we go by this order, that prima facie view that no service of government employee can be spared to render his service to a purely private organization cannot be allowed. So if cannot be allowed, there is a stay.
Yeah. Well, therefore, this view, perhaps, to my respectful understanding, is contrary to the Rule 15, 2D and E of the CCS conduct rules. That is the distinguish that I make in this. So now, my lord, the fact I'm coming, my lord.
Your simple case is that in terms of Rule 15D, you have your permission.
Correct.
So it's a cooperative society, therefore you can continue.
Yes.
If that be so, will that mean that the permission granted, we assume that permission was granted, you continued. Will it mean Rule 15 that once permission is granted is for forever?
For 5 years, my lord.
5 years. When 5 years is will
5
be over?
years is ending by another few months.
So go back.
No, my lord, it is not a question of going back. Kindly appreciate one thing.
No, we understand that part our view is that Rule 15, that permission is not given, cannot be given for an employee to take salary from some government and continue somewhere else for years after years. That cannot be intent of that.
I respectfully bow down.
That cannot be intent
cannot-
of that rule.
No, that cannot.
Intent of the rule is that you can be member of a cooperative society, you can be a shareholder.
Correct.
I can be a shareholder of that milk cooperative society. Suppose
Correct.
I am having some cattle in my, that some conditions are fulfilled, I can be a shareholder. But can I, giving up here, be a managing director there for years?
No, my lord. 2006. That is not permissible, extended. That is extended. And
No,
my lord,
that is extended.
shareholder and other thing, except for my
You are
lord.
taking salary from whom?
A secretary.
Salary from the state.
State.
And you are whole time serving as a managing director.
That is what
Man-
fundamental rule 11, 12 and 13, 14 covers. That
No, well,
I have no issue on that, no quarrel. Lord. Respectfully, no quarrel on that.
You cannot be whole time. You can be for promotion and something like that. You can be a shareholder and that too with the permission of the government. In
Therefore-
a cooperative or in a banking.
Yes, my lord.
Okay, we
Now-
agree on that.
Yeah, the first, that proposition is over. my lord.
Hmm.
The second limb of argument is,
Hmm.
in view of the fact
Hmm.
that all my conducts,
Hmm.
all my actions taken as a managing director of a private organization,
Hmm.
can the department initiate departmental proceeding against me or not? That is the big question. Let the Reverend Advocate General answer to this. I'll close my brief. my lord.
Okay, before that, just let us just note the facts.
Yes, my lord.
Where is the
39.
how an IS officer be a chairman of an private union? Tell us. There must be some control of the government over these cooperative societies. I think so.
No, my lord, that my lord will appreciate that G Telefilm's judgment. If my lord will try to rule that, or if not, my lord, that BCCI, Board of Control for Cricket in India, my lord, that judgment. Now, a IS officer can also hold a position in a.
Where is the that cooperative societies memorandum?
Yes, yes, my lord, I'm coming to that. My lord.
Sure.
My lord, I will place the facts list of dates. My lord.
Hmm.
My lord, kindly see this. Annexure 1, page 23. This, I was promoted as a district veterinary officer, my lord. That is 21/5/2005. Now, Annexure 2, page 24 to 25. Order dated 31st May 2006. I was directed to take charge of Managing Director IDDP. Page 25, my lord, order dated 28/7, by which order the petitioner was appointed as MD again, my lord. Now, Annexure 3, my lord, page 26 to 55. Notification dated 3/9/2007. Arunachal Pradesh Milk Produce Union Limited, Nirjuli, is registered under Section 9 of Arunachal Pradesh Cooperative Societies Act 1978. my lord. Now, my lord, page 47. That is the important, my lord. Page 47, my lord. 17.3, appointment of MD APC MUL, my lord. Page 47, my lord. Appointment of.
What is the bylaw?
This is bylaw, my lord, which I am referring to. It starts from, my lord, page 27.
Tell me.
Page 27. The bylaw starts from page 27. Page 26.
No, tell us. It says chairman means a member of the board who is elected/nominated as chairman of the union as per provision of the Act, rules and bylaws. What is this Act, rules and bylaws?
These bylaws.
Where is the provision of nomination? Tell me.
Here, page
the bylaw.
47,
Huh?
page 47, 17.3,
Page
47, my lord. Appointment of managing director.
No, I want the chairman.
No, he is the managing director.
I'm
No,
managing.
I want the chairman.
A chairman, my lord. Well, just for a moment, my lord, that I have not marked because I marked what is the relevant.
Chairman is 15.8.
15.8. Page 41, my lord.
Then state is having a control.
For the first time, my lord, there was an election. New
The
chairman.
first board of members English chairman may be nominated by state government. The first board may nominate a period of 2 years. Government may review the names of the board of directors. Government may continue the same or make such changes as it deem consider necessary by issuing of fresh order extending the period of 1 year more. However, such period shall not exceed more than this is the first. Then members shall be from the chairman of the Milk Society's affiliate union and qualified content election as per this bylaw. Yes, yes.
Yeah. My lord, then page 47, 7.3 is the appointment of managing director.
Page 47.
Of the petition.
Yes.
That my lord will see for selection of managing expert panel shall comprise secretary, so and so, so and so, so chairman, my lord here, chairman of the union. Then my lord does 18.1 qualification for the MD, my lord, 18.1. 18.1 is the qualification of MD of APC MUL. Then, my lord, 19.0 to 19.1.21 is the power and functions of managing director, my lord.
It's a whole time thing. 19.0 to 19.1. I have seen that.
Yes. Now, my lord, kindly come. These has probably our done here at annexure 4, page 4, 56, 15, 56, 57. By there was a board of director meetings, 25/5/2012, page 56, my lord.
What is this? Page 4, annexure 4 series.
4 series below that is first is at page 50. This is how I was appointed. Page 54 is important below 7. The following resolutions were adopted. The members present authorize Dr. Migo Riba present managing director, IDDP, to function as the managing director of so and so as per draft bylaw 19.0. Page 56.
Page
56, annexure 4, we are within annexure 4 series only. Page 56. That was the 25th May 2012, it was held.
page 55.
56. Date was 25th May 2012. And Malad, besides other normal following resolutions were adopted, kindly see. Resolution number 3. The Board of Directors of APCMPUL ratified the appointment of Dr. Mugariwa as Managing Director of so and so for further period of 5 years with effect from 2012. 17. And thereafter another ratification is there. Now 7th and 18th September 2016. Next page 57. Here, Milord, the extension is SC 1, 2, 3, 4. Milord, kindly come. The meeting of the APCMPUL ratified the appointment of Dr. Migoriba as a Managing Director of APCMPUL for a further period of 5 years with effect from June 2017. Milord. I am not holding this post illegally, Milord. Third paragraph from the bottom is important.
Page
57. That my lord is seeing. The meeting of the APCMPUL ratified the appointment of Dr. Migoriba as Managing Director.
Kindly come to page 54, paragraph 3.
54, paragraph 3. Yes.
Read it.
Paragraph 3.
54.
It is resolved that the activities of Dairy Cooperative Society involves creation of infrastructure for milk procurement and processing through grants from Government of India. That is what I was referring to other instrumentalities.
Yes.
Other,
Kindly proceed.
Yeah, well, just therefore, the chief promoter, chairman of union shall be Secretary, Animal Husbandry and Veterinary and Dairy Development, Government of Arunachal Pradesh, as per provision of the draft bylaws. This is talks about the draft bylaws. Board of Directors still 100 Dairy Cooperative Society is created under IDDP and affiliated with the union. The ad hoc committee of APCMPUL shall manage the affairs of the union for obtaining approval for Government of Arunachal Pradesh regarding formation of the union and registration process. The following ad hoc committee, so and so.
So government was having a role. You are being managing director at the wish of the government, not on your own. So as that you are a shareholder or a milkman by any document. How can you be a managing director without being a milkman?
I am appointed by these minutes. I have not gone off my own.
So then they want to come you back.
No, but not.
That part is no issue.
No issue. I am not quarreling. Let me clarify this Article 12 and other instruments. The G telefilms I have referred to. Board of Control for Cricket in India also I have referred. Referring to these two judgments, I have done one case in Arunachal. It's relating to Indira Gandhi Technical University 0.
There, the government have funded about 2.5 crore for construction of the boundary wall of that university. A RTI application was sought to be filed, but the university authority denied it. Interestingly, according to their memorandum of office procedures, they contain that a commissioner education shall be representative in the board of directors, can express view on behalf of the state. Similarly, my lord, if the state government, even a single penny is being spent, my lord, or given to any NGO, it comes under the definition of Article 12 in the form of other instrumentalities, my lord. So we are not quarreling on that, my lord. Nothing on this.
No, spending money is not the only issue. Even private, when public function is performed, then no money is required. Why money is required? When it performs public function, then it will come. There is no doubt on that.
Now
where is your suspension?
Suspension, my lord. That is how at page 58. I know, just first, before that, my lord, kindly come to page 58. Order dated 6/12/2018. I was posted as manager of regional breeding formula.
Page
58. 58. I stand at serial number 4. MD, I'm posted as manager regional sheep breeding farm.
Okay.
My station is there. Happily, I'm drawing salary. Then at page 59, subsequent page, my lord, by order dated 5/3/2019, I was removed as MD Milk Union, my lord. This is, my lord. Then next is certificate annexure 7, page 60. Certificate of charges that I have given, my lord. Then I have filed this read petition 126, my lord. I have given the order copy, my lord. The wrong order copy has been annexed here, my lord. I apologize for this, my lord. Read petition 126 was filed, my lord. And interim order was granted, my lord. This order, subsequent order has been annexed instead of the main order, which
Where is the interim order?
my lord, which I have furnished there, supplied a while ago.
This is 126.
Yes.
Okay.
My lord, I apologize for this.
Okay, no issue. Okay.
Then, my lord, that this is how now, my lord, annexure 10 is important, my lord. Inquiry order against me was instituted. Page 66, my lord.
This is not as such against you, but against the functioning of the plantain union, not against you. Isn't it?
In that, even how I have been suspended, that the big question comes. My lord, kindly for a moment, my lord will kindly flip back to page 66. If we...
You had enough. You have enough of everything.
Now, my lord, kindly come to page 67. I have a contention
67. I am at page 67.
Yes. Now, I was relieved with Dr. Longri. Dr. Longri was asked to take over the charge. How a person can be a judge? He has a prejudice opinion against me. You cannot. You have not applied your mind here, my lord. Therefore, this has caused great prejudice to me, my lord.
Okay, well, if he who is appointed as inquiry officer?
That Dirkipa, inquiry officer, at one point of time, this Dirkipa was also asked to hold a charge.
No, Mirsi Gombu. Mirshi Gombu is asked to appointed the study the functioning of the APM.
That is page 66, my lord is referring to.
Page 66.
I am referring here at page 67.
No, no. Why are you saying that this is prejudging and all?
Prejudging is that, my lord, kindly come to that.
How they are involved?
59. 59. Kindly come back to page 59.
This is D. Longri.
Yes, D. Longri. Here, kindly see. D. Longri shall henceforth look after the
He's the
works.
presenting officer, not the inquiry officer.
But then, my lord,
He's a lawyer.
No,
he
but-
knows it.
no, but he will influence.
How can he influence? If you have any grievance against the inquiry officer, yes, he is a bias. That is a different issue. But what is a presenting officer? Who will present the case of the government? And you will have your own person who will present your case. Can government say, no, no, don't give this man as a, I thought that this inquiry officer was earlier something, somewhere related.
No, but kindly see, kindly appreciate. For
Yes, I am appreciating. He is a presenting. What is the meaning of presenting officer?
He has to
is
collect
a lawyer who will present the case for the department. Where is the question of being by? He will definitely support government.
in higher task that present officer,
you will
presenting
have a right of cross-examination of his witnesses.
in higher task, if that presenting officer manipulates the document and present the
How
case,
can he
on behalf- he is the one who will collect the
You
document.
will have a cross-examination. Right of cross-examination.
But cross-examination was not given.
You have already been punished.
I'm
Inquiry
punished.
report has been submitted.
Huh?
Inquiry report. That's why we are challenging. We are challenging entire inquiry report, my lord.
Which inquiry report is submitted, then there are some other stages under CCA rules.
No, 23, rule 23 is there. We have also filed application for revocation because your process thus is not sustainable in law. Because
Copy has been given to you, inquiry report.
yes,
Now there will be second show cause, I think. Then you will have a chance to reply. You reply it, then come back to us.
that
With
is
all this bias and all, show them that this is bias, how bias is caused, how the decision is influenced, where no cross-examination is granted, then prefer an appeal and come back to us.
my lord, kindly come to page 107. That is what I have referred to. Annexure 50.
107.
Reply come request for revocation of suspension orders by lateral dated so and so 17.
We'll give them a time to decide on inquiry report.
Correct. That is one aspect. Kindly see, my lord, whether I was there in this organization or not. That is, my lord will see at annexure 15, 108 and 109, the permission that I have sought from the government to occupy this post.
Mr. Advocate General, you advise them to modify the bylaw. This is your organization, but your role is not even disclosed, though everything is been done by the state.
I will point out certain other documents, which will show that government has virtually absolute control.
It's generally it is
And
having.
what has happened is, just to briefly begin, there is no dispute that he is an officer under the veterinary department.
Not disputed, no quarrel.
No quarrel. There is no dispute that his appointing authority is the secretary veterinary department.
Yes.
There is no dispute that he has been drawing his salary from the state.
No dispute, my lord.
No dispute. Now, what happened was, in 2005, central government gave us some funds for promoting this milk production. Then it was decided that this union will be formed. And it was resolved in the first meeting itself that till the bylaws are finalized and that process is complete, registration of the union, etc., till then, the secretary of the department will function as the chairman.
That is at 15 point something.
And
He was brought in as managing director in 2006. Thereafter, since he is now the managing director, what he does is, he does not allow, in the meantime, the union has been registered, the bylaws have been approved. The bylaw says that an expert panel will make a recommendation for appointment of the MD. He tactfully avoids that process. There are repeated resolution after resolution where he himself is the signatory, I'll point out. He says that I should continue as MD. And that is how he merrily continues from 2006. He continues like this. Now, we find that in the process, what is the reason of this tenure of posting? The reason is that the person does not develop a vested interest in a particular station. Now, since he has been continuing since 2006, rampant anomalies start happening. The government decides to, first step the government takes is, since the secretary is the appointing authority, he is asked to hand over charge as MD. He is placed under suspension. He challenges this in the first repetition. WPC 126, that is the primary challenge.
Correct.
There, your lordship has seen the interim order passed by my Lord Justice Tagia. The interim order says that this is all these facts, the control of the government is not even brought to the notice. So therefore, my Lord Justice Tagia presumes that this appears to be a purely private organization. How can you put a government person there? However, the order becomes contradictory because stay is granted. By virtue of the stay, a government officer got
Stay was granted in view of the fact that how can you spare a government person to be there, whereas
he himself is a government person. So now that is how he continues. But there is no stay of the suspension which was put to challenge. There is no stay of express stay of the direction to him to hand over charge as MD.
No.
My Lord Justice Tagia simply says in the order that this is stayed, therefore he continues. Now, in the meantime, as has rightly fallen from your lordship, a general inquiry into the functioning of the union is directed. He challenges that. I don't know what locus he has to even question that. In the meantime, disciplinary.
He challenged that in the second repetition.
Second repetition. Now, in the meantime, since suspension was in contemplation of departmental proceeding and there is no stay of the suspension order, the departmental proceeding has proceeded. Inquiry officer has been appointed. Inquiry officer has submitted his report. He has been given a copy of the report.
He participated in that
process. He participated. And now, after the inquiry report is submitted, he comes and challenges the appointment of the inquiry officer itself in the third repetition, saying that how can it be done? The answer is I'm in fact grateful. I was not intending to go into all this because I thought this is not even necessary. But since my friend has brought it to your lordship's knowledge, your lordship will find, and I need not trouble your lordship with the specific rules. CCL rules. Who is the authority to place an officer under suspension? The appointing authority. Who is the authority to initiate a review? Appointing authority. So secretary has done all this. So, in my respectful submission, my lord, these three repetitions can be perhaps disposed of with a 2-page order, saying that first he has to establish his fundamental or legal right. There is, forgetting about fundamental, there is no legal right to even convict. He is more of a deputationist. His initial appointment was, in addition, I will point out those documents, my lord. If your lordship will first come to, if your lordship will kindly, I have made my preparation in 126. If your lordship will kindly take a 126.
126, no?
126, Michelle.
Your affidavit?
No, repetition itself will do.
Okay.
Here, my lord, in these three repetitions, I don't think there is even any affidavit required. If your lordship will first come to page 17.
Yes.
Just to, although he is not even disputing, but just to point out that his substantive appointment is in the veterinary department. This is an order issued on 21st of May 2005. His name is at serial number 5, M. Riba, veterinary officer. He is posted as DBO, Nirjuli. This is on promotion. On the recommendation of the Departmental Promotion Committee, the Governor of Arunachal Pradesh is pleased to promote the following veterinary officers to the post of District Animal Husbandry and Veterinary Officers, etc. And serial number 5 is the repetition. So the fact that his substantive appointment is in Veterinary Department of the Government of Arunachal Pradesh is not in dispute. Now, my lord, in the meantime, your lordship will just make a note of 2 facts. While this was happening in 2005-2006, the central government came up with this scheme called Integrated Dairy Development Program. And this is presently renamed as National Program for Dairy Development. Under this, about 750 odd crores was released. And it was decided that a union will be formed, which is known as Arunachal Pradesh Cooperative Milk Producers Union.
Where do you get that?
Your lordship will come to page 46.
One is page 19, where please to order managing director.
I'll come to that a little later. But these facts are prior to that.
Page
46. Your lordship will first make a note of the date at the very top. 12th August 2006. This is a meeting held on so-and-so, the office chamber of Managing Director, Intensive Dairy Development Program, etc., etc. Now, if your lordship will come to the second paragraph in that page, line about 9 from top, towards the right side, there is a sentence starting in view of the fact.
Next page, page
No,
47.
same page, page 46. It is line about 8th line from the top. In the second paragraph, there is on the right hand side, your lordship will find
in view of the fact.
Precisely. In view of the fact that the time is not ripe for giving full autonomy to the union for handling of the milk procurement and processing, as the infrastructures are still under the control of the government, the milk union has to be partially managed by the government. So it is not only government has a role, it is managed by the government partially. And since there is less DCS in the state, it is not viable for the union to bear the cost of running the dairy plant and chilling center and the salaries of the staff of the dairy processing center. The members present in the meeting propose that the management staff of the staff and the expertise shall be handled, it should have been handled by landed by the Department of Animal Husbandry and Veterinary and Dairy Development, Government of Arunachal Pradesh, till such time the union has full expertise to handle affairs of its own. So now, if your lordship kindly turns the page, the resolutions are there in the next page. This, your lordship had pointed out to my learned friend, Mr. Tara. The following resolutions were adopted, paragraph 3. This is what your lordship had already noted. Chairman, etc., how it will happen. Now, serial number 7, bottom of the page. This is the petition.
Prepare a draft bylaw.
No, the last serial number 7 one.
To
prepare and who? The petitioner. And thereafter, what happens is interesting. In the meantime, bylaws are prepared, and this union is registered, which your lordship will find at page 21.
Page
20.
Just a minute.
Registration certificate.
This is to show that on this date, the union was registered, and last sentence, the bylaws adopted by the society have also been registered. Now the bylaws are in existence after this date, 3rd September 2007. And what do the bylaws say? If your lordship kindly comes to the bylaws at page 21. Your lordship will find at page 40. bylaws provide for a manner and method of appointment of the managing director. And your lordship is aware of the law, right from Nazir Ahmed, that one. And bylaws in the case of a union hold the status of a statute.
Correct.
If a manner is prescribed, it has to be done in that manner alone or not at all. Now, 17.3, appointment of managing director. The managing director of the union shall be appointed by the board of directors on the recommendation of the expert panel prescribed under bylaws. And the expert panel is provided in 17.4. And your lordship will see who is the serial number 1 in that expert panel.
Expert panel is at
17.4. The selection and recruitment of managing director, the expert panel shall comprise of the following members. Number 1 is secretary to the government in the Department of Animal Husbandry. Number 2 is chairman, who is supposed to be an elected member. Now, number 3 is director, Department of Animal Husbandry, Veterinary. He circumvents this entire process, and this is what he does, madam. If there is an additional affidavit filed in this by the petitioner himself. In this additional affidavit, your lordship will find
additional affidavit. Additional affidavit.
Page 6.
Is
6. He now requests the authorities, on the request of Dr. Migo Riba, so-and-so, DBO, he is continuing as DBO marketing in Nirjuli, from where he is taking the salary. He may undertake works of so-and-so union as managing director without any remuneration in addition to his own duties as DBO. So he says that I know that I am a substantive employee of the government. So that I continue to get my salary, I will not give that up also. And I may be allowed additionally to continue as MD, and this is in 2017.
That's 7 to 4 is page 7.
And
Page 7.
page 7.
Page 7.
Now your lordship will kindly come to the page 50 of the writ petition.
Page 50 of the writ petition.
Writ. This is one of the resolutions in 2016. And your lordship will kindly see serial number 4. The meeting of APCMPUL so-and-so ratified the appointment of Migo Riba as managing director of so-and-so. And your lordship will kindly see who has signed it. It is he himself.
Okay.
Judge and jury, everything. Now, this is how he continues. He continues and anomalies start happening. That is when we passed 4 orders, which are under challenge in 126, just to indicate what is under challenge. One is page 52.
Just a minute.
Your lordship may take down the repetition number.
126.
126. So in 126, these are the things under challenge. Page 50.
Longridge appointment as MD is under challenge.
Correct.
Isn't it?
That's what
Migo River shall hand over all charges.
applies here, below.
Dr. Migo Riva shall hand over all charges and responsibilities relating to DBO marketing so-and-so and MD so-and-so to Dr. D. Longri, Deputy Director, etc., etc. So this is challenged. He basically doesn't want to leave the chair of MD. Next comes page 53. He had already handed over charge. That handing over charge itself is under challenge. And your lordship will find that Migo Riva's signature in this. In page 53, Migo Riva himself has signed.
Okay, then
So
see,
after handing over charge, he comes and challenges his own handing over. Now, the next thing under challenge is page 69.
page 69.
69.
There is no page 69.
Oh.
69 seems to be some other repetition.
In the other repetition.
69 is the challenge to the inquiry, to the affairs of the society. That is repetition.
391.
Huh?
391.
391.
391. 391 challenges the inquiry.
Inquiry against him.
Not against him.
No, there is another repetition. That is
inquiry against him. Okay. Now,
inquiry against him is under challenge in 391 and in 138.
Oh, that is what I am asking. 130 is the middle.
Middle
one.
General inquiry.
General inquiry.
Again, regarding the affairs of the union. That is under challenge. That repetition can be dismissed only on the ground that he does not have any locus. Who is he? Now, the third repetition.
He challenges that departmental proceedings suspension.
After having submitted to the inquiry, he did not, your lordship will just take a note of the dates. Show cause notice was issued on 17/3/2019. Thereafter, inquiry officer was appointed on
17.
7/3/2019. 7/3.
Okay, 07.
07.
3/2019. Okay.
Show cause notice was issued. Inquiry officer was
appointed
on 19/8/2019 after he submitted his reply, etc. And in fact, your lordship may make a note of the date of his reply also. He submitted by filing a reply on 14/3/2019.
14/3/19.
Thereafter, inquiry officer appointed on 19/8/2019 and the inquiry report was submitted on 15/6/22. After he finds that
2022.
That was again because he did not.
But there are some procedures thereafter. What is the provision? If you are not satisfied, then you will have to
That is rule 23, Miller.
He has been given a
report only.
Inquiry report, and he has to now respond to the report. It is absolutely out and out premature.
107, Miller.
Even thereafter, the person is aware.
391. The answer lies at annexure 15, 107. Sorry, this is not disturbed.
So now, after the inquiry report is submitted by the inquiry officer, he files WPC number 391 of 2022.
Challenging that entire inquiry. Because of that, appointment presenting officer is one ground. Now, that is the only ground.
No, that is one ground. And another thing is that CCA rule will not apply on me. That I have the answer in the subsequent.
Okay. According to you, CCA rule will not apply to you because you are the managing director of a cooperative society. Okay.
I have the answer. I will point out.
Now,
where you reply?
Now, so far as the first repetition is concerned, the challenge is to what? He has been asked to hand over charge. I am the appointing authority. Government is the appointing authority. I will decide whom to keep there, whom not to keep. Since the expert panel, now the bylaw provides for an expert panel to make a selection, we will go for that. That is, so he has absolutely no legal right to continue as a. The second thing under challenge is where the handing over of charge to
other person.
Again, no legal right. So first repetition goes on that count alone. The second repetition is to the general inquiry directed against the
cooperative functioning of the
cooperative. Since the government has control, and if there are anomalies, we have not taken any action. We have just asked for an inquiry to be conducted. What locus does he have to check? And so far as the third repetition challenge to the inquiry is concerned, it's out and out premature, especially after having submitted himself. It is not now open. It will be directly opposed to the principles of approbation and reprobation. You have submitted Had you come against the show cause saying that it is without jurisdiction, only that would be the only ground available. Otherwise, in a
Jurisdiction and no notice.
no. Otherwise, your lordships in exercise of 226, where is the scope? And especially after having some. So therefore, my lord, although this appears to be very voluminous, my lord, I don't think your lordship will take more than 3 pages to dictate this.
Yes.
My lord,
Sorry, before my lordship, just for perhaps our all satisfaction, CCA rules. The fact that it is the appointing authority who has the power to suspend.
Rules, just mention the rules.
It is not the conduct rules that my friend was referring to. It is under the CCA. Rule 10 is the power of the appointing authority to suspend. And Rule 11 is the power to impose penalties. And thereafter, my lord, all these orders are appealable under Rule 23.
That is what I want to.
that is, I replied.
Even the order of suspension is an appealable order under Rule 23. Not to speak of the final decision taken in the disciplinary proceeding, even the suspension. So therefore, my lord, in my respectful submission, my lord, this petitions deserve to be dismissed, and by virtue of the interim order, he has continued for extra 3 years. He cannot say that I will continue in perpetuity as the managing director of this. Or else you submit your resignation.
And
don't take salary.
And be a milkman.
Be a milkman.
Milkman and be a shareholder and
Become a milkman.
get selected, but he has to be selected by you only, not by the shareholders.
No, he can become a member.
He can
become a member.
He can become a member, but to become a managing director, again, you will have to select him. Again, bias will come. That this person has, yes.
First legal submission in the form of rebuttal is no affidavit has been filed. Thereby has admitted the allegation that I have made.
Okay.
That is the law. Government waived the right to object by means of filing affidavit to revert the allegation that I have made. That judgment I need not to refer.
Okay.
My lord, kindly come to page 68 of read petition number 126.
Yes.
The answer of foundation of all submission of Revered Advocate General.
Page 168.
68.
Yes.
The answer to the whole foundation of the submission advanced by Revered Advocate General is palpably visible here, my lord. Here is the chairman who writes this letter. Kindly come, my lord, page 68 of 162. It writes to the secretary who says, "Sir, with profound regards and humble submission, I, as chairman of Arunachal Pradesh Cooperative Milk Producer Union Limited, would like to lay before you following few words for your kind considerations and sympathetic response. The Arunachal Pradesh Cooperative Milk Producer Union Limited is a registered body and under Arunachal Pradesh Cooperative Societies Act 1978, Act 3 of 1979, and it is a statutory body to function. The registered cooperative body functions under the guided bylaws approved and vetted by the Register of Cooperative Society. My lord, kindly mark this. Not at the whims and fancies of the government that you can interfere in my activities. The Arunachal Pradesh that next paragraph. The Arunachal Pradesh Cooperative Milk Producer Union Limited, APCA, MPUL is not under the control of government of Arunachal Pradesh and can only be intervened under Cooperative Societies Act 1978. What is the requirement? You follow? First, you write a letter, even to initiate disciplinary inquiry, action against me. You ought to write letter to the chairman. No, you do not have. Otherwise, my lord, the most valued.
Do you remember the Priyanka Estate judgment citation?
2011. Priyanka says your lordship is referring to the Supreme Court or our division bench?
Our division bench.
I forgot that. I also
No,
read
no,
once.
that, our division.
2010. I can find it out. That is in reference to which point?
In reference to the point that whatsoever action you have done, it is beyond the bylaw, that cannot survive. Because in Priyanka estate, permission was granted beyond the scope of the building bylaw.
Bylaws.
Then it was ratified by the appellate authority refused it. Then final authority is the state allowed it and allowed it to construct the building beyond bylaw.
Up to
Priyanka estate
up to
12.4. Priyanka estate said nothing can be done. No appellate authority can grant anything beyond.
Because that is ultimately what.
That is Priyanka estate. Your answer is to the Priyanka estate.
Correct, Milord. This page 68 answers.
The answer is Priyanka estate.
Correct.
What is the procedure of selection of bylaw of a managing director?
That is 17.3.
What it says?
That panel. But Milord, what I understand. Selection.
No board can, so if it is selection, if it is bylaw is prevail over anybody, even the secretary.
Correct.
That's why I'm asking Priyanka estate.
I will keep this.
Correct, Milord. So, Milord, now the proposition is whether.
Division bench judgment of our High Court.
Yes.
Regarding Guwahati municipal corporation
I-
building bylaw.
Even Supreme Court has approved that.
Affirm it.
And I'll find out. Now, Milord, now there is a two ratification of my appointment. Two ratification of.
All false.
Milord,
In view of Priyanka estate.
correct, Milord. But then, Milord, the apex court also clearly has void or irregular order. If it is not corrected by means of a judicial course, that even if that is void ab initio, remains to be a valid law. Therefore, my appointment is correct. I will furnish that 2008 judgment. Milord.
Yes, give us.
Yes, I'll furnish that judgment. Milord. Void or irregular order. Just pull up volume 2 in my blue book. But that order is there. Milord. That contains it. I will furnish the judgment. Now, Milord, such is the case that has been. Well, I have made a note. Now, Milord, kindly pick up contempt order. Contempt petition, Milord.
Will you take up the contempt now?
No, not now, but just for a reference, Milord, that my file is missing, Milord. There is an order passed by Lordship Procedural one. There is a violation of that order. There it has clarified that I can continue to be the managing director. Because the government has come in the form of instruction. Lordship Procedural was order. I apologize, Milord.
They have rightly interpreted the order. Okay.
Correct. So therefore, law is settled that I don't come under the purview of the government. Now, Milord, page 68 of 126 further demonstrate one more thing, Milord. That I am an independent body. I am the chairman. The chairman is writing to the secretary saying that you have exceeded the jurisdiction. Now, Milord, we are in a democracy. Revered Advocate General will also agree with me, Milord. On the proposition, be it executive, Milord, be it judiciary.
You are in a democracy
Yes.
when a power of election is given by virtue of some authority of law.
Correct.
In your case, the authority under law is the bylaw. Bylaw is not giving any authority to elect the managing director. Matter ends there.
No.
What is the question of democracy?
No. But what I'm saying, my Lord have propounded another thought process. My thought process is something different, Milord.
No, my thought process is guided by the law.
That's
your whole right to be appointed as a managing director, to continue as a managing director will rest upon certain law. In his case, the bylaw. Now let me forget for a time being that you are a substantive post, this, that you can be.
we are not correct. on
Now you entered as a managing director in a given facts. That is also clear how you become managing director. There is no dispute, that is part of your writ petition. Now, moment the cooperative union is formed, all earlier decision is overturned by and should be redone again by virtue of the bylaw. The bylaw say managing director should be an appointed person by an expert panel to these are the persons. Now you are admittedly not elected by that person.
But this is not
By whatsoever majority of the shareholders you are elected as a managing director is a nullity and therefore you cannot continue. That is the judgment. Dismissed. Order to follow.
my lord, kindly allow me to make
But
this.
order is on Wednesday.
Yes. Now, whatever
Priyanka
dismissal,
says GLR is, division bench is 2007, 1 GLR,
In 2007,
1 GLR 473,
1 GLR
473.
470 and the Supreme Court
Supreme Court is 2010, 2 SCC
2010 2 SCC
27.
27.
Division bench is Justice B.S. Reddy and Justice B.P. Gottu.
I think you were also part of that. We all were part.
That was the case.
Now-
Half of the bar was part of.
now, my lord, let me conclude with two small submissions. The proposition that I was making, be it judiciary.
Your initial appointment as managing
coming.
director cannot be faulted with.
I mean, I'm
That is
coming.
fine.
Yeah,
There
I'm
is
coming to that.
No quarrel on that.
I'm coming to that. Be it legislature, be it executive, be it judiciary. If these three organs imbibed in the Constitution of India functions within their limit, there will be no chaos and conflict in this country. Here is a case where there is a conflict created by the executives. You are transgression into a jurisdiction where you do not have the power to exercise anything else. Therefore, my lord,
We'll hear it not at the behest of a person whose appointment itself is illegal. We'll hear and appreciate such argument
see,
when
my lord,
real
my lord, see, thus writing judgment is prerogative of my lord. And even
my problem is I expressed my views. I could have.
No, my lord, even we cannot by a figment of imagination challenges that. Respectfully, my
See, my
I'll
view,
not do that.
my view is this. Your initial entry as a manager, your substantive post is in the Department of Veterinary or Animal Husbandry, whatsoever, we'll see it. Your entry in as a managing director is by virtue of a resolution of the state itself, not by anybody else. It's by state itself for a period which is called a transformative period.
Transition period, I can.
Transitional
period.
Transitional period. During this transitional period, you were asked to continue with this with certain responsibilities.
But that has further extended.
Just come on. This is my understanding. Just change my views. I'm open to change your views. Then the union was, the responsibility given to you was done. And by virtue of that bylaw, it says that the managing director, how a managing director is to be appointed. Now, the moment bylaw is adopted, that will become the law. As you have argued, that this is a separate identity, institution. Separate institution cannot be controlled by government. Even if we go by your argument, the managing director is to be appointed or elected or selected as provided under by the bylaw. Because
Therefore-
bylaw is the constitution of
Therefore, my lord, writ of quo warranto should have been filed.
just
Without filing writ of quo warranto, can my appointment be disputed in this manner? No.
just
My lord, kindly come this.
just a minute.
How I have been.
We are dealing with a writ petitioner who has come to this court saying that my fundamental or any other legal right is violated. So therefore, we'll first try to understand what is his legal right. Isn't it? So therefore, the moment that cooperative bylaw is there, by virtue of law, you cannot continue as a managing director. And all subsequent action not done by the government or done by the shareholders are invalid in law. That's all.
Correct, my lord.
Just to give a further one impetus to what has fallen from your lordship. Your lordship is aware of the law, my lord, right from Gadeshwar law. Your lordships will not, in exercise of 226, issue a mandamus, which will have the effect of reviving it.
No, that
We cannot ask by a mandamus to do something which is against law.
well, the proposition something is traveling beyond the corridors. What I understand, most probably many a times in the bar, it is respectfully stated that making a window shopping in the castle of Chinatown. But my case is not making a window shopping in the castle of Chinatown, but for my legal rights that a authority
That is
has.
what we are trying to have
Yeah.
it. That what is the legal right of this person?
My right is, my lord, whether I'll submit that 2008 judgment, my lord,
Yes.
whether void or irregular order, unless it is not cured by means of a judicial decision, that law action has to be valid. Otherwise, my lord, Section 21 of the General Clause Act was available with that. You have a power, if not Section 14 of the General Clause Act, power to appoint, power to remove. You have not exercised this power. Neither you have exercised Section 21 of the General Clause Act. So therefore, my lord, kindly, this particular thing may kindly be noted, my lord. My appointment has been ratified.
There is no doubt on that.
Yes.
Your
So-
appointment has been ratified not
So
by once,
therefore-
twice or thrice. Your appointment has been
On the-
ratified.
On the teeth of page 68
68.
of page.
And the chairman says, "Oh, Mr. Government, you have no right to interfere with our decision."
Correct.
Isn't it?
That is what
So you cannot do it.
you cannot.
But we'll see. At the same time, we cannot be oblivious of the fact that you have come to this court with an allegation that this is my right. We'll have to verify first that this is your right.
Yeah.
If you are having a right to continue as a managing director, we'll interfere with their decision. Now, the first question is what is your right to continue? And it rights fall from, according to you, the decision and rectification taken by the union itself, by its board of directors, by its shareholders. But whether
The government has a power.
no, forget about the government. Whether the board of director or the shareholders are having that power to do. That is the answer. If they are having no power, then whatever right, no right will accrue to you. If no right is accrued, we cannot issue a writ of mandamus or even for that writ of certiorari. So CAV or dismiss.
No, I'll furnish that judgment.
Okay, you furnish this
Because
judgment.
if I
Hearing concluded, list this matter on Thursday for delivery of.
Correct, I'll furnish that.
In the meantime, the learned counsel may give their written note of argument.
Correct. Great. It is always pleasure to be again, sir.
And this also. Just a minute. Item number? 9. Yes, madam.
Yes, sir. I'm for respondent number 5, Your Lordship. We need some more time, Your Lordship. We have not received the
weeks' time?
comment, your
2 weeks'
lordship.
time?
Yes, your lordship, 2 weeks'
Okay.
time may be given.
The learned counsel for the respondent number 5 prays for and is granted 2 weeks' time to file affidavit in opposition. List
Well,
accordingly.
Unless your lordship.
Lordship, here in this case, Lordship's state respondent, Lordship.
No counter file.
Yes, Lordship.
Who wish to file counter?
I'm praying, my lord, some time, my lord.
Yes, for respondent number?
Lordship, it's all the respondent, Lordship. It's respondent.
No, nobody has filed affidavit.
Yes, Lordship.
Okay. The learned counsel for the respondents prays for, learned counsel for the respondents pray for and are granted. How many time?
3 weeks, my lord.
Lordship,
3 weeks time to file
Lordship, this is
affidavit.
last chance, Lordship. There is no interim order, Lordship. That's why, Lordship, always they
The
will not
learned
file.
counsel for the petitioner has expressed urgency in this matter as there is no
Interim order, Lord.
interim order.
No, my lord, my humble submission, they are praying for review of the DPC, my lord, by which they have been get promoted, my lord. There's no urgency, my lord.
No, Lordship.
Yes, I am
Urgency
yet
is
to
there,
receive
Lord.
instruction,
That
my
is
lord.
his
Yes,
submission.
Yes.
So file the affidavit.
My lord, I am yet to receive
Release is
instruction, that's why, my
exactly.
lord.
Considering the above, it is provided that the affidavit be filed within a period of 3 weeks, 4 weeks,
4 weeks.
4 weeks from today.
Difficulty here is, my lord, after receive instruction, my lord, they need
4
to.
weeks, that's why we are giving you 4 weeks. Then you can show this order and otherwise we will proceed.
Yes.
Okay, 4 weeks. Then from.
Much obliged.
Yes, Mr. Chaudhary. This is for you, not your.
My pleasure. This is regarding my lord. Petitioners are,
Pleadings are complete.
pleadings are complete, my lord.
Who is for the other side?
The issue regarding my lord, this is whether they are entitled to old pension benefit of old pension scheme. They were recruited in the year 2008, your lordship.
Selection was completed.
Till selections, benefits was published before 2008, my lord. Before 2008. And my humble submission is that, my lord, this is squarely covered.
It's not fair.
Adjournment.
This is the
Senior friend, if we want to go for disposal, then my part I'll do tomorrow. I'm here.
No, he will not be here. When you
No, I will not be.
He will not be here.
I will not be here, my lord.
Then any day.
My lord,
Keep it.
actually, this issue is squarely covered by the division of judgment of our division bench.
We have seen that. Let him have a, but he will try to, he may try to interpret in a different way. So we'll have to hear it. We cannot say that this is a covered case or disposed of.
That is there after.
Is that it?
That
If that we can say, give him the copy, and if he considers that this is a covered case, we'll say disposed of covered case.
Then your lordship will.
When?
Any day.
But he is coming in the month of January or any before that, any date.
My lord.
Your other case is fixed on
18th.
18th of January.
18th of December, my lord.
18th of December.
No issue.
My lord.
Or before that.
No.
18th.
After that.
After that.
After that.
When?
After my lord, in the January, any day, my lord, in January.
No, you can come.
Right.
Since you are coming from outside, so we thought that we'll fix as per your convenience, or we will be in the month of January. We'll say in the month of January.
Month of January.
Month of January. Okay.
The lordship may admit it and put it for hearing also.
Okay. Okay. The matter is ready as regard service and pleading. Accordingly, admit this matter for hearing and be listed for hearing in the month of January 2024.
Finally.
You make a mention if necessary.
Deploy.
Yes, what is this? Additional affidavit.
Yes, my
You
lord.
are supposed to file additional affidavit.
No.
Huh?
Lordship, the beneficiary already getting the benefit of pension, so may pass the orders.
You do not want to press this. You have got the relief.
I think only the relief has been given.
Okay, you got the relief.
Yes.
It is submitted that the grievances of the petitioner has already been redressed. In that view of the matter, the present writ petition stands closed.
Right, it's also-
Yes, dusty service you have taken,
Yes, Lordship.
but any affidavit?
No, Lordship. We have taken dusty service.
How do you know that you have taken dusty service? You left whether you could serve or not. You'll have to file an affidavit.
There is, I'm for respondent matter, but there is a note matter of 24 matter.
You are appearing for the private respondent.
No matter. For the State Information Commission matter.
State. And what?
I think they file an affidavit matter.
Where is the
A
affidavit?
completion of matter, dusty service.
Okay. Just a minute.
For the 24. Note dated matter. 24.
Respondent number 3, Miss Hage MP. Okay. Peruse the affidavit filed by the petitioner as regards service of notice upon the respondent number 3 through Dusty, full stop. It is seen that notice has duly been served in presence of 2 witnesses, full stop. Accordingly, service upon respondent number 3 is accepted. You want to file affidavit?
No.
No. Okay. In that view of the matter, as the matter is ready as regards service, let this matter be listed for in the admission column. When you sought an adjournment in the morning.
Yeah, admission column.
After?
16 of this month. Please on the 16th of this month.
On 16th of December. In the meantime, parties may exchange their pleadings.
My plate, my lord. This matter is a land acquisition matter, my lord. And in this matter, during the period.
Respondent number 1 and 4, affidavit.
Yes, my lord.
Important. Their affidavits are important.
Yes, very important. my lord.
Respondent number 1 and 4.
And respondent number 30, my lord.
Respondent 30 also.
30 also, my lord.
30.
Commanding officer.
Commanding officer is you will file.
Yes, my lord.
My lord.
The learned counsels for the respondent number 1, 3, 1, 4 and 30.
30.
Pray for and are granted. How many time? How much time?
My lord, in fact, I'm having the first copy, wherein only 27 respondents are.
That is why.
So therefore, my lord, I am appearing on behalf of respondent number 5 to 27, my lord, private respondents, all private respondents.
Here are 29, not 30, 29.
29.
29 and 30.
Yes.
General Officer Commanding Sub,
Yes.
Eastern Command, Indian
Yes.
Army.
My lord, subsequently, that may be they implemented, but however, my lord, in the original petition, my lord, it is.
No, we have served, my lord.
We have served.
Yes, we have served.
My lord,
Okay.
will take instruction.
Okay. When? 4 weeks?
4 weeks.
4 weeks time. You can take.
And even the private respondent 5 to 27, he is also appearing. But now he is representing the Union of India. Whether he can represent the private respondent or
Could
not.
not then. Who are 5 to
5 to 27
private
is the private
respondent.
respondent.
In original petition, my lord, only 5 to 27 is the private respondent, my lord.
Now, how they are related? They have been paid money.
No, not paid money. We have challenged the land acquisition
No, you have challenged the land acquisition,
Yes.
but how these private persons are related?
because land acquisition has been only assessment has been done
In
only
respect of
against the respondents.
But you have no problem with
No
their
problem.
assessment.
No problem.
They are informal parties.
Yes, my lord. No issue.
They assess in respect of them and paid. According to you, not only them, we should also. It is not your case that they should not get.
Yes.
Is it your case that they should
Yes,
not
yes,
get?
my.
They should, according to you, they should get it. No problem.
Yes.
But give it to us also. Our lands are also occupied.
Yes, ma'am.
This is your case.
Yes.
They are performers.
Yes,
Okay.
Papa.
Performer. So that they can come and say that we are also having land, we have been given.
Our contention
And
is,
if they say that no, you are not having land, then it will be different.
Yes,
Then there will be issue. It will depend upon the affidavit.
my lord,
Yes, my lord.
Okay. List accordingly after 4 weeks.
my lord. Develop.
The present contempt petition
My lord,
is filed alleging. Yes, tell us.
my lord, I've been telephonically sought information that this writ petition is writ appeal is no further stayed.
Huh?
There is no further stay on the writ appeal.
File an affidavit because there is an interim order. See, page 35. No. Where is the interim order? DB
Yes.
by my lord Justice Tagia and Justice Borua. Where is that?
My lord, this order dated 26/06/2023
My lord,
may be got,
Later on, interim order was not extended.
not extended.
Not extended.
Yes.
Where is that order that not extended?
The order dated 26/06.
Where is the order plus stay order?
That is my affidavit.
I have seen it somewhere.
Page 7 of my affidavit.
Page
7 of my.
Your affidavit. Okay, the present. Just a minute. The present contempt petition is filed alleging willful violation of the judgment and order dated 28/1/2022 passed in WPC 184 / within bracket FE/2019. However, the respondents preferred an appeal against the said judgment, and the division bench by its order dated 17/5/2022 stayed the aforesaid judgment till the returnable date. Subsequently, such interim order was extended by order dated 16/6/2022 and 16/2/2022. Full stop. However, it is submitted that subsequently such interim order was not extended. Yes, if not extended, do comply with.
My lord,
Sometime.
we need actually the counsel for the petitioner is Delhi-based advocate, so he will be available on 22.
Be that as it may, a prayer for adjournment on behalf of learned counsel for the petitioner is made.
22 of this.
Made accordingly. Same is allowed. Full stop. Please this matter on
22 of this month as he have other case fixed on
22nd of
November
2023. But you'll have to do it.
I have to tell them.
If there is no stay, you will have to comply it. As simple as that. But he wants an adjournment anyway, because it relates to some departmental dismissal and all this.
Most of like.
What to do? Take first steps. Service is not complete.
Yes, Lordship, on the last occasion, the court had asked me to provide documents which determines the existence of this firm and a new address. So accordingly, I've got this enlistment papers from the department. And also I've received this new address from their GST website.
The learned counsel for the petitioner submits that she has collected the new address of the sole respondent.
Yes, Lordship.
Accordingly, she prays that she may be granted a week's time to take fresh steps upon response. Sole respondent. Prayer is allowed.
Yes.
List accordingly.
Lordship, date may be fixed.
No, you have to take steps. Then steps to be taken within a period of 5 days. The notice is made returnable after 6 weeks.
Lordship,
Least
I
long.
have to travel from Guwahati that.
Least on. Give a date after 6 weeks. Take the steps today itself.
Oh, yes, Lordship.
Then
I
go
will.
back Guwahati and after 6 weeks you are fixing a date. After 6 weeks, give a date. 19th of December 2023. Register to list with a service report. Yes, respondent number 4.
My lord,
No
I am
counter
bring
file.
No, my lord.
sometime, my lord.
What sometime? Tell us.
I have received the instruction, my lord. A week will do, my lord.
Okay.
1 week, my lord.
The learned counsel for the respondent number 4 submits that he has received instruction and accordingly 10 days time may be granted to file affidavit in opposition. Prayer is allowed. List accordingly.
My lord, on the several occasions, they took time for filing affidavit.
This is we are giving.
And each time, my lord, the interim passed earlier has to be extended time and again. So they have
Interim order passed earlier shall continue until further orders.
My lord. Definitely.
Yes.
Yes, Your Lordship, the petitioner is
You are
present
careful-
today also and earlier also. I'm for respondent number 1 to entry. We have not received extra copy also, Your Lordship.
But none appears for a petitioner on call. Service report in respect of respondent number 4, 5 and 6 are still awaited. Full stop. The learned counsel for the respondent number
1 to entry, Your Lordship.
1 to entry has submitted that she has not been served with the extra copies. Full stop. The petitioner is directed to serve the required copies to the learned counsel for the respondent number 1, 2 and 3. Full stop. List after 4 weeks. Early hearing.
Not immediately. We are facing a serious constitutional threat. We are without a public service. My prayer would be on Thursday.
I have no issues, but I'm appearing only in item number 24.
We'll make some adjustment. But if the other council, Mr. Dilip Majumdar is appearing. We'll make some adjustment if necessary. Let it start at least on Thursday.
Your Lordship, I'm appearing from on behalf of.
The point involved is not very.
Majumdar.
Point is whether Article 317 will apply or not. Factually, there is a little bit. I don't think overall it will take more than an hour.
Yes, Dilip Majumdar has instructed me to fix the date after 14, Your Lordship.
After
14.
That by then it will be too late.
Because I can understand this matter was on earlier occasion also there was an urgency and there was a direction from the division bench to take it early.
State functioning without a public service commission, your lordship, you can imagine, we are. not
Whether
able-
you with these people or some other people, that is a different thing,
Different.
but it should function. That
It's
is
a
our lookout.
constitutional authority afterwards. Let us start on Thursday, we will accommodate. That is a gentleman's
Who is
order.
your senior?
Dilip Majumdar.
Dilip Majumdar.
My friend can start. If for some reason Mr. Majumdar cannot come, we will accommodate, we will adjust. That is not a problem. Maybe Mr. Pangi can conclude his part. I will conclude.
Why don't we start on today's Monday, Wednesday?
Wednesday, my lord, there is one part-heard matter that is fixed. Or else let my friend start his argument on Wednesday. I will come and give my reply on Thursday.
See, because problem is this, we are also having less time, no? So if a judgment is to be delivered, these are very important issues. You may take half an hour, but my judgment is not it. I'll have to give reason either way.
Let my learned friend Panging start on Wednesday. I will give my reply on Thursday. If necessary, Dilip Majumdar, we will adjust 1 or 2 days here and there.
Here and there. Okay. The present ISC Swensu is filed for early hearing of the present batch of writ petitions. Full stop. It is seen from the record that matter was heard at length and was also reserved for judgment. However, as the learned judge who was taking up the matter was transferred, the matter was released. Full stop. The matter relates to selection and appointment of members and chairman also.
Chairman is not an issue in this case.
Members of the Assam Public Service, Arunachal Pradesh Public Service Commission. The learned Advocate General has expressed serious urgency in this matter. The learned counsel for the respondent has just submitted that
Petitioners.
Respondent.
They are the petitioners.
Learned counsel for the petitioner has also submitted that they have no objection if the matter is heard at an early date. Full stop. Accordingly, as agreed to by the learned counsel for the parties, release this matter on 8/11/2023 for hearing.
And understanding is that I will do my part on 9th.
We'll continue. Accordingly, I stands disposed of.
The next matter is also same. Obliged.
In next matter, there is no IA.
There is an IA. In both the cases, we have filed IAs.
Okay. Same order in IA 183/2023 and 182/2023.
Deeply obliged.
But I'll expect a short note after the hearing.
We have already, in fact, it is already on the file. Main file.
Already there. Okay. Okay, it was because it was.
WBC 4091 minute.
Mr. R. Saitya, learned counsel for the petitioner, submits that he has instruction to withdraw. He has instruction from his client to withdraw the present petition.
However, my lord, I may plead
Liberty. Okay. With a liberty to file a fresh petition if with a liberty to file a fresh petition. Who is for the government? Anybody? Yes, Kamal Saxena.
I'm for the state council.
But anybody from PKTRE?
Well, I will inform him, my lord.
Huh?
I will inform him, my lord.
Okay.
The main grievance is against the state government, my lord.
State government. Okay. The state council has not also objected to such prayer. Accordingly, the present writ petition stand dismissed on withdrawal. Interim order, if any.
No, there is no
entry. Okay, no entry. What is this IA?
Well, IAs are being filed by the NSPC, my lord, for deferring the, my lord, hearing, my lord,
Okay.
to take a decision by the government.
Okay. Close. What you do is, you write in the IAS that in view of the order passed in the writ petition number 40 of 2021, nothing survives in this IA. Accordingly, the IA stands closed.
Liberty may be
Given. Liberty, accordingly, this matter stands closed on withdrawal with the liberty as prayed for. That will be in the writ petition. And in the IA, you write it in view of the order passed in the writ petition, this IA stands. Two IAs. Yes.
Lordship, in the morning, I have mentioned for unlisted matter, Lordship. And I have been informed by the colleague that since the standing counsel for the RT department is not available today, Lordship.
So tomorrow we'll take up
Lordship.
tomorrow.
Lordship.
You change it with tomorrow.
Lordship. Deeply obliged, Lordship.
Yes. List is over.